Do offshore trusts work in bankruptcy court as well as they do in state court proceedings? The answer is no, and here's why. So the asset protection benefits of the offshore trust are essentially that you as the potential debtor are placing your assets beyond the jurisdiction of a domestic U.S. court. In other words, the judge in the U.S. and our court system generally does not have jurisdiction to impose orders against a trustee located offshore, as an example in the Cook Islands, where most offshore trusts are formed today. So it's the jurisdictional protection. A offshore trustee is likely to ignore any kind of court order or collection action imposed by a U.S. judge. Bankruptcy courts are different. Federal law, bankruptcy law, gives bankruptcy courts and bankruptcy trustees worldwide jurisdiction, meaning that the legal jurisdiction of the bankruptcy trustee and judge is not limited to the state or district where the court sits. The jurisdiction is granted worldwide, meaning, in other words, a bankruptcy court has jurisdiction over all the debtor's assets wherever located. That's the paraphrase of the wording, meaning that a bankruptcy debtor, whether the assets are in the state where the court is, or even in the country where the court is, the U.S., all those assets are still subject to the jurisdiction of the bankruptcy court. That means that if a bankruptcy court issues an order, the order can be imposed on trustees wherever located. In the U.S. or otherwise. And because there's certain treaties with foreign countries, that the treaties enable the bankruptcy court to domesticate or move their orders and impose their orders outside the United States. That's not all. Secondly, in a typical domestic collection, the creditor has the burden of finding and collecting the debtor's assets using collection tools that the U.S. Statutes or courts are made available to the creditor. It's the creditor's job to find assets and collect the assets. In bankruptcy, it's different. In bankruptcy, the law imposes upon the debtor the requirement to find and bring back his assets to the jurisdiction of the court. So if you're in bankruptcy, you have the legal obligation, you have the legal duty to discover or list your assets and do what is necessary to convey those assets to the bankruptcy trustee, who then can administer the assets for the benefit of your creditors. And the fact that you have assets that are yours by virtue of a beneficial interest in an offshore trust does not relieve you of the duty to bring those assets back. And if you fail to do so, that the bankruptcy court can impose civil sanctions against you for contempt of court because you have not obeyed the order, the lawful order of the bankruptcy judge. So there are many reported cases where a bankruptcy debtor has refused the obligation to repatriate assets from offshore trust, and the debtor has found himself in jail with an order that he must repatriate the assets in order to get out of jail. And these are sort of storied cases where it shows that the offshore trust does not work well in bankruptcy. Now, the fact that the bankruptcy is, laws are different. Understand, most people who have offshore trusts don't file bankruptcy. So it is important to understand that if you are setting up an offshore trust and you do have creditors coming to try to collect judgments, that please resist any advice from a bankruptcy attorney or any other attorney that you can solve your problems by filing bankruptcy. And please do not believe that this offshore trust that does work well in civil courts is going to protect you once you decide to file a bankruptcy to eliminate your debts. The offshore trust works, it just doesn't work in all courts in all situations.